Ladies and gentlemen, welcome back. We hope that you enjoyed your lunch and the networking session you had. Okay, before we begin our next session, may I request that we observe 1 minute of silence in respect of the crew and passengers of the ill-fated aircraft MH370. Thank you very much, ladies and gentlemen. Okay, right now, moving on to the next one. We've been waiting for this, right? It's going to be a very, very interesting topic, yeah? And we will see if this is within the parameters set by the corporate policy and regulations. Okay, the speaker is Ms. Geeta Kandiah, the Director of Trademarks and Design Division of CAS International Sdn Bhd. Okay, and she's going to be talking about bring your own device to work policies. Okay, and Ms. Geetha frequently shares her IP or intellectual property expertise on local radio station BFM, Business FM 89.9, and has contributed articles for various local and overseas publications. Her comments on case law in Malaysia have been quoted in publications abroad, many publications abroad, and she was recognized for her exceptional work in the IP field by Prestige magazine in 2010, where she made it into the top 10 of Malaysia's top 40 under 40. Ladies and gentlemen, I'd like to call upon to the stage to enlighten us with something very, very meaningful, beneficial. Please welcome Ms. Geeta Kandiah.
Good afternoon, everyone. Everyone is always reluctant to take the session after lunch, and that's because everyone has come back with a full stomach, and also there's some disappearances today, some of the crowd's missing. But I'm very pleased to be able to speak today. It's very interesting when SK contacted me saying, why don't you come up and speak on BYOD? And I was like, to a HR community. So if you have any questions, please feel free to ask them. I touch on confidential information mostly, and that's very relevant to business owners and to HR trainers as well. I've been in CAS International for 8 years now, and I head the Trademarks and Design Division, and confidential information falls into my division as well. Okay. The challenges of BYOD to work policies. Now that we're just back from lunch, I had some suggestions of doing some exercise, but instead of doing an exercise, I will tell you a story. I had a client who had some intellectual property assets to protect with us, so in the meeting he was telling us about how his experience with his board of directors one afternoon. He was actually having a meeting over Skype with his board of directors, and there was 8 of them, and the session took about an hour long. And after the Skype session ended, the CEO, our client, forgot to switch off his Skype. And the video cam was still on, and he was really smartly dressed, had a tie and had a coat, had a jacket and a shirt on. But he stood up to get out of the room, and he only had his boxers on. And all of the board of directors saw that. So that brings us to BYOD. How many of you know what BYOD means? Very few. Either you're very shy or you haven't Googled it while I'm talking up here. It's bring your own device. So the story relates to bring your own device because the CEO was actually using his own device, his laptop, at home to have a meeting with his board of directors. And I'm sure many of you today have been checking your emails, SMSs, probably even entering into your office servers to check on documents whether your employees or your colleagues have updated them. That itself is bring your own device. You're using a device owned by yourself, or it could be the company supplied it to you. But today, when I'm talking about it, it's mostly bringing your own devices, the one that you own yourself, your own laptops, your own smartphones, or tablets, and using them for work purposes. Now, why is BYOD? What is so great about bringing your own devices? There are a lot of advantages. The use of technology by the mobile workforce on personal technology, personal hardware for work purposes. The advantages are it improves the flexibility. Earlier, Ms. Ann was speaking, and you would see that among the top 3 reasons a person stays in a company is work flexibility, the ability to move around while working from Starbucks, working from home. And again, with women, it's being able to juggle your family and work flexibility gives you that. So bring your own devices has that advantage. Then you have it boosting productivity. Being able to work from anywhere, even if you're in line waiting for something to be done or some document to be lodged, you can still be working. And then you have, it suits preferences of Generation Y. Generation Y are around 20 to 34-year-olds. That's a large portion of the workforce today, and it's just going to be increasing into the workforce. And many of the Generation Y, the millennials, like the work flexibility option. And they do not like sitting in front of the same PC day in, day out, working from 9 to 6. As Ms. Ann said that she's from the baby boomers would know. They're very much used to it, the fact that you sit in front of a PC and you go home, they're comfortable with that style of environment. That's not the case with Generation Y. It also allows the employee to use the hardware that they like and they're familiar with. So now those are the advantages. Let's see in practice, is BYOD being used widely or is it just a term? So here are some statistics. This was a Samsung survey conducted, and they found that in UK, 56% of the 100 large business CIOs and IT decision makers surveyed said their company promotes BYOD for work. 47% of companies reported that staff are better engaged with BYOD, with employees at 46% of those companies delivering enhanced productivity as a result. In EU, 31% have a formal BYOD in place, while 21% have an informal policy. Now, many of you, either trainers, you've probably been working with companies that have BYOD in place, or you're in companies that have BYOD in place, and I am guessing that most of them have an informal policy. At CAS itself, CAS started in 1999, and it was very much a traditionally run company, working from 9 to 6. In fact, the only flexibility we had was at one point, the boss said, okay, 9 to 6, some mothers want to come in earlier so that they can go home and attend to their kids. We can start at 8:30 and get home at 5:30 to beat the jam. That was the amount of flexibility that was given to us. But in time, we've changed so much, mainly because of Generation Y. We could see that retention was very difficult. To keep them, you had to be flexible. It's not a yes, no, maybe. It was a yes, it had to be done. So then it became, we have now called DDOs, which is called a drafting day off. You can actually work from home, and you don't have to be drafting something. You could actually be working on anything work-related. You just have to prove, we have all this, fill in a form and come and show to your supervisor what had been done. If you were actually drafting anything, it has to be sent to the client the next day or within 2 days from returning to office. All this just to show that work has been done and it was not misused. So that is an informal policy. There are some of you probably have policies similar to that or other policies, but that's an informal policy. So you can see how 21% have an informal policy done. And At the moment, 30% of staff take up the option of using their own device for business. Businesses that permit BYOD save 17% or £6 million on average on yearly communication costs. This is mainly because it's their own device, the employee's own device, and their own communication costs. There might be allowances given, but almost everyone who has a smartphone has data plans, and they don't mind doing work from the phone without paying anything to the company itself. So you do save on cost. Other studies, this is not a Samsung study, this is a CompTIA study, shows that 74% of Generation Y workers said they use a smartphone these days, compared to 37% of baby boomers. You can see how the figures are double in terms of Generation Y compared to baby boomers. So bring your own device is not a yes or no, it's definitely a yes going forward. So in terms of whether should you even implement it, that's a given that you should, but what do you look at? What are the disadvantages? Let's visit that now. So now, in terms of disadvantages, the main disadvantage is the data, all of your data in the company that your employee is processing may be confidential or may be partially confidential. And if they're using it from their own device, it's easy to be assessed, and easy accessibility it also means that it's easy to be misused, easy to be deleted, easy to be transferred for any reason at all. So easy access may not be a good thing when it comes to confidential information in your company. Now, earlier someone asked me, what is IP? IP is intellectual property. Intellectual property is basically property created by your mind. So it's intellectual creations that are property. Confidential information is a type of intellectual property. These are not restricted to patents, trademarks, industrial designs. That's a traditional type of intellectual property. Any intangible creation that is of value to business is an IP asset. So some of you might be thinking you don't have IP assets, but you do. Every company that has a USP, that has a customer database, that has pricing list that's confidential, all of those are intellectual property. This chart, this graph shows that there are, in earlier days, in the industrial era, where manufacturing industries and factories were very, very, very important because we were producing products, were the way forward, were successful. See, 90 to 95% on the left side, 90 to 95% of the assets were tangible assets. So there you're looking at stock, you're looking at factories, and only 5 to 10% were intangible assets. And then in the modern globalized business, on the right side, you see that 5 to 10% are tangible assets. Those are physical assets, and 90 to 95% are intangible assets. So when you look at that and talking about the examples here, you're looking at Bata, any coffee shops, kopitiam coffee shops, and on the right side, the examples are Microsoft, Nestle, Nike. The reason being, on the right side, a lot of the assets are patents, are softwares, are things that you can't actually see. You can't see and you can't hold. If Coca-Cola is not there, but let's take Coca-Cola for an example, you might think that they sell a lot of products, so they'll be on this side of the graph. But it's not the case, because if let's say, touch wood, all of the factories of Coca-Cola were to catch fire or a disaster hit them, the factories go down, Coca-Cola's value is in two things. Mainly, I'm sure they have a lot of other patents around, in bottling and so on, but the two main values in their company is, in fact, why don't I throw it to you? What are the two main assets that they have in their company? Okay, I hear formula. Yeah, that's the ingredients for making a Coca-Cola. The second main asset? Customer. Okay, that's a good answer, but it's the one on this side. I heard someone say brand. So that's it, the brand and the ingredients. The company, regardless of the fact that physical assets have been wiped out, can still rebuild their brand and their drink itself, the product, because of the ingredients they have. And then, yes, customers are still around, they can still build it up. And with Coca-Cola, I guess, not so much customer list, it's more of a supplier list and their partners that they work with bottling. But again, that they will most probably have it in terms of knowledge, they still remember those kind of details. But you're looking at two main things being brand and the ingredients, and ingredients are called trade secrets in intellectual property. Trade secrets are those kind of ingredients in Coca-Cola, KFC Better, for instance, which no one knows what's in the KFC Better, but those are trade secrets that have passed down over generations. So these are where intellectual property assets are now. It's extremely important, especially as we move towards a knowledge-based economy. Every speaker here has said that human capital is vital. And the reason for that is human capital are the ones coming with the intellectual creations for the company. The ones working for you are constantly innovating and constantly creating something that is valuable for the company. Okay, so confidential information is a subset of intellectual property rights. Now, what is your confidential information? Here are some for you to try to relate to your company. List of customer preferences and so on, workflow systems, list of suppliers, special arrangements with the suppliers. Some suppliers give you a discount, some suppliers give you better credit policies, company policies which give the company the competitive edge, pricing policies, marketing strategies. It does seem very vague and seems every company has this, but every company has all of this, which is unique to the company itself. Other confidential information could be contractual relationships with third parties, company strategies, seasonal strategies, for instance, especially in the retail market, business forecast, details of research undertaken. Some of you are from universities, you're looking at research done, or if you're having collaboration with third-party companies who are commercializing the research, all those research are valuable information. Even failed research projects. Failed projects are important because it shows your competitor not to spend money and effort and time in that specific research project because it has failed. So these failed research projects are still important to your company. Financial data, which is also a given. It's obvious that that's very confidential. So now, how is this related to BYOD and what can you do? Here, on what are the rights of the employer, this most likely most of you know, but just a refresher if you don't. As an employer, you own all intellectual property assets that your employee creates for the company, if it's within their scope of work. So putting it in perspective, let's say there's a tea lady working in an IT company, and the tea lady, from observing how things are happening, and if she has some sort of background in IT, has IT knowledge, either in hardware or software, sits down with her family member who also has that kind of knowledge, and with the office resources, she comes up with an invention, creates either a software or hardware. The question is, who owns the IP rights? Her job scope in the company is to serve tea, not to create any inventions. But the fact that she's used office resources it makes it a bit gray. The company has some rights because she's used office facilities. If she has not used office facilities and she's only there to make tea, and that's not her job scope to actually create any invention in that field, then the rights to that invention belongs to her. So it really depends on what your employees are hired for, what is in their employment contract. Sometimes you can also term any invention, regardless of whether it's in their job scope or not, it will belong to the employer if the knowledge that they've used is that was gained during employment. But if there's nothing at all in the employment contract, then you're looking at what was in the job scope and were they using office work facilities to create the invention. So in most cases, it does fall back on the employer. The IP assets goes back to the employer. So earlier we were talking about bring your own devices. So we're talking about devices, then we're talking about confidential information related to your company. So that confidential information was done in their job scope, all that emails, all that data that they were crunching belongs to you. So now what happens when they resign? Or they walk away, or it goes missing, the employees goes missing, the devices go missing. What happens? What if the devices fail? How do you handle the risk of allowing for BYOD? Here are some tips. Firstly, you should get a technology consultant and get all security measures implemented. There are a variety of security measures that you can implement. The moment you, that's why I earlier said, do you have an informal policy or formal policy? A formal policy will include all of this. The moment you decide to implement it, okay, let's be flexible, let's allow for flexibility. You're looking at, even if you don't get technology consultant, you can get your IT, if you have internal IT person to look into it, or you can outsource it, hire an IT personnel just for this. You're looking at encrypting document files. When you encrypt it, no one can read it, only the person who has the key through the document. Using passwords, install wipeout capabilities, audit logs on those who access server, a variety of other things a technology consultant can advise you. But basically, it gives a whole policy of how things will be handled the moment you implement the BYOD using Office data on your own device. Then you can also perform regular audits to understand how the information is being used, by whom, when, from, to, where, and how. You can also have a backup approach. You should have a backup approach. Having a backup approach could be manual, on a weekly basis, have them transfer everything onto the server, or you could have it automatically transferred to cloud. Again, it really depends on how you implement this. I was speaking to Eugene and Wendy earlier, and they will later talk to you about the softwares that they have, which are very relevant. I was telling them earlier that they should be speaking before me, mainly because they're talking about bring your own device, talking about softwares used on devices, various devices, making it easy for you to work from home. But the point being is that if you use specific softwares, whatever data that you're using, work-related data on that software will be automatically saved in cloud. So the version in the office, so if anything fails, if the device is stolen, if the device crashes, you still have the information saved in a third-party place. And then you set access based on a need-by basis. What this means is that not everyone needs access to everything on the server. You have different departments, and you have different people in each department as well. So you will have to start analyzing the data that you have, that everyone has access to. Do they need access to this information? You can compartmentalize everything and only allow people who need access to have access. If they need it at different periods of time, and if it's possible and practical in your office, then you will be actually giving them passwords when they need it, changing them when they don't need it. So this is actually being very wise with what information can be accessed by employees. Once I was giving this talk and a client actually said, why is there so many measures in place? Do you not trust your employees? And before I could answer that question, another person who was attending the talk actually stood up and said, you can trust no one. Not even family. And being in the field that I am, we handle trademarks, designs, and a bunch of intellectual property assets. We've seen sibling rivalry, siblings fighting over trademarks that the brother created and let the brother-in-law take care of it while he went to India to start another business. When he came back, he found out that the trademark has been transferred to the brother-in-law's name, and there's a lot of hassle in trying to resolve that issue. But so the point is, it's not that you don't trust the employees, and probably when you position this to them, you will have to actually explain the need for having a need-to-know basis. Secrecy, access based on a need-to-know basis. When we implemented that in our office, it triggered a lot of unrest and not so much hostility, but a lot of confusion as to why are we actually implementing this? Do you not trust me? And the moment trust issue comes up, then the whole not liking the workplace and not liking the ambience of work arises as well. So then we had to actually explain the reason for why we had to set these parameters. You also have to have procedures to handle situations where the device is stolen or lost. And that's, again, what the previous slide said. You can install a wipeout capability on the basis that you already have a backup approach. You can educate employees in security awareness and company security policies and procedures. This can be done when you're recruiting them or regularly to remind them of how important information is, the information they're dealing with is. Have employees sign contracts. Well, they already signed an employment agreement, so you just want to have relook at the clause that's relevant to the confidentiality part. Or NDAs, if you're working with outside consultants, have a non-disclosure agreement. Now, the truth is far more interesting than fiction, they say. So let us look at some case studies. This was a case where it was decided that employees cannot be prevented from using their own general skills and knowledge. Now, the reason I brought in this case studies is mainly because when you're talking about bring your own devices and the main risk is being that confidential information be taken away. So for you to go home today, the one thing I would like you to learn is what can you do if information's been taken away? What is confidential information? And how do you prevent it from happening, from it being misused? In this case, Fazenda Chicken and Fowler, it's not a local case. This was in the UK. What happened here is the plaintiff is involved in a business of breeding, slaughtering, and marketing fresh chickens. In 1970, Fazenda Chicken Limited is a very large company now. They were really old, and in 1973, the plaintiff employed Fowler as a sales manager, and at Fowler's suggestion, they adopted a method of distributing chickens, fresh chickens. They started selling them through refrigerated vans that traveled in a specific route every morning to a specific area. Each van salesman received sales information regarding the customer names and addresses, the general limits of the routes, the quantity and quality of goods that were expected by that customer, and the prices charged. 7 years later, Fowler left and started his own business providing the exact same services in the same area as the plaintiff. There were only a few differences, and the differences were detrimental to the plaintiff. The differences were that Fowler, he knew the routes, he knew the preferences of the clients, and he knew the timing. So what he did is he approached the same customers, told them that he can deliver the chicken earlier, around half an hour earlier. That's good for any businesses, especially those in the F&B business. And I will offer it cheaper. So if you've got a promptness factor there and a cost factor there, definitely a lot of customers left Fazenda to go with Fowler. Unfortunately for Fazenda, some of the staff also left. 5 of the plaintiff's van salesmen and 3 other employees from the plaintiff joined Fowler. The van sales division had dropped when Fowler left, but when 8 of the experienced staff left, it became unprofitable for Fazenda. So the plaintiff sued Fowler and the 8 ex-employees on the basis that they were stealing confidential information. So this was information, it's listed there, names and addresses of the customers, most convenient route to be taken to reach to the individual customers, the usual requirements of individual customers, days of the week, times of the days when deliveries were made, and the prices charged to the individual customers. Now, do you want to take a guess of how this case fared out? Hands up on who thinks Fazenda succeeded in this suit. Okay, I see around 4 or 5, 6. Who views that Fowler succeeded in this suit? More for Fowler. Very interesting. It's an employee market out there from the looks of it. All right, here the Court of Appeal, affirming HC means affirming the High Court decision. So both the Court of Appeal and the High Court decided in favor of Fowler. This was after 39 days of trial. It's a lot faster in the UK to process cases. Okay, there was a few items that were important in this case. One is that the confidential information that's revealed to the employees can be restricted from their usage after they leave employment only if the information was treated as trade secret. So the information that you have, the confidential information that you're revealing to your staff, you may think that they know that it's confidential, it's a given that it's confidential, but no, it's very important, especially in court cases. The first thing the court will see is that was that information actually treated as a trade secret? And it's not just putting a stamp on a file saying it's confidential. It's telling them over and over again, do not reveal this. And like the measures I spoke about earlier, having need-to-know basis, policies, passwords to access certain data, changing of passwords regularly, all of this are taken into account in court when they observe whether was that actually confidential information. So here they felt that it was not actually a trade secret. All the items listed in the previous slide was not actually trade secret because it wasn't treated as trade secret. So number two, to determine whether the information is trade secret, they had a test. So the test is, it's necessary to consider, number one, the nature of the employment. Example, if the employee regularly handled confidential information and recognized it as such information was only handled by a restricted number of employees. And number two, the nature of the information. So first, nature of employment. The second was nature of the information. And the third one, whether the employer had stressed the confidentiality of the information. And number four, whether the relevant information could easily be isolated from other non-confidential information, which was part of the same package of information. This is basically, if you lump it together with a lot of other information that's clearly not confidential, then it will be considered non-confidential. So you have to isolate it and treat it as confidential. Third one, applying those tests, in this case, neither the sales information as a whole, nor the information about the prices charged by the plaintiff fall within the classification of trade secret. Though the information about the sales prices is of some value to the competitor, it could not be regarded as plainly secret or sensitive. Now, the other two things that were decided is sales information was written within the knowledge of Fowler and the ex-employees of the plaintiff, and the use of the information was merely use of the general skills and knowledge gained from a previous employment. Okay, what this is a skills and knowledge test. If it's skills and knowledge that one has gained through their employment, it's no specific information, it's just a skills from the trade, you cannot restrain them from entering a competitor's employment and asking them to leave the employment or getting any suit against them, mainly because if you've learned the skills of trade and you go out and find another workplace, it's your livelihood. So the court recognizes the fact that you can actually go out and get employment for other places in a similar industry using the skills and knowledge that you have from the previous industry. So it dissociates skills and knowledge, but what is skills and knowledge? It's a very, very gray area. So that's why treating the information as confidential and proving in court that he approached these clients, these specific clients at this time, and this information was treated as confidential and he's misused it. So that's where misuse of data comes in. You're not touching on skills and knowledge of that person. So here they said that it was skills and knowledge of Fowler. So that's where it got tricky at this part, because if the Facenda could show that it wasn't skills and knowledge, it was confidential data, then they would have succeeded. Number 5 is the defendants are not entitled to take a copy of the plaintiff's instructions away with them, but insofar as the instructions cannot be called trade secrets and he carried them in his head, he is entitled to use them for his own benefit or for the benefit of any future employer. So you see again, it's really the emphasis on was it treated as trade secrets. Number 6, specific trade secrets so confidential that even though they may be necessarily be learned by heart or carried in your head, the employee cannot lawfully use the information. So if you treat it as a trade secret and they have gone out and used it without stealing any proprietary information, without making photocopies of a database or saving it in the thumb drive and leaving the employment, they have it in their head, it's still considered as misuse because you've treated it as trade secret. Okay, so that's for Facenda and Fowler. Now moving on to the local front, I have 2 cases in the local scenario. This happened in Malaysia. Here is Smith Scientific, Sdn Bhd, and Ong Han Suan and others. In this case, what it was a company that distributes medical devices to universities and research institutions. And they had an exclusive distributor, the plaintiff had exclusive distributor rights from a company overseas. And the first to 4 defendants were ex-employees of the plaintiff. The 4 defendants left the plaintiff company and started their own company. And they approached 3 of the plaintiff's customers offering the same products for cheaper. That's the way, I guess. Everyone, it's common sense to actually try to undercut your employer, your previous employer, to get the business from the same clients. One of the customers eventually purchased from the 5th defendant. So one of the plaintiff's customers jumped ship. The 5th defendant also approached the overseas principal of the equipment and was appointed as a distributor of the products in Malaysia. This is very sad because the plaintiff had an exclusive distributorship agreement with the principal, the overseas principal. And when this defendant came in and negotiated again with the principal, and the principal caved in, the distributorship agreement became non-exclusive. So the plaintiff had a competitor, and the competitor was an ex-employee. The plaintiff sued the defendants for breach of duty of fidelity and good faith and breach of confidence. Here the court held that the duty of good faith or fidelity prohibits an employee from using confidential information during and post-employment. Duty of fidelity and good faith usually arises when it's a person in power, usually directors and managers. They have a duty of good faith towards the ex-employer. Where there is a confidential relationship between 2 parties, the court can infer an implied contract arising from the relationship. So here again, they inferred the contract, they inferred the fact that it should be kept confidential on the basis that it was a senior person that left the plaintiff company. The plaintiff also had evidence to prove that the 4th defendant had printed out information relating to the plaintiff's customer database, suppliers, and cost prices, and that evidence was not refuted by the defendants. So the defendants did not have anything to say about evidence that was shown in court. The method of compilation of the list of customers, their specific needs, and cost prices was confidential, even if method of arriving at the selling price of the equipment was neither a unique or intellectual work. What happened here is the defendants were arguing that it's very easy to come up with a cost price. It's the selling price. It's a cost price with a little bit of margin. But because there was evidence that information was taken out from the plaintiff company, and that was adduced in court, it was a clear act of misappropriation. Here, the quotation that was sent out by the plaintiff to the customers and the quotation that the defendants were sent out were found to be similar. So again, that's why there was, the case was in favor of Smith Scientific Sdn Bhd. The defendants, in their defense, they said that they collected the information from the market, but they didn't have any evidence to substantiate that claim. The defendants claim, what I said earlier, that you cannot stop someone from joining a competitor based on misuse of confidential information unless you have evidence, because it's skills and knowledge that makes you continue your livelihood. So here, the defendants were saying that the plaintiffs were trying to restrain of trade and trying to put them out of business. And the plaintiffs refuted that, saying that it's not a restraint of trade. They don't mind them being in the same industry, but it's more so of the misuse of information, the confidential information that was privy to the plaintiff that was used. So in this case, unlike the Fessenda and Fowler case, you can see, Smith succeeded, but mainly because they were treating that as confidential, and the information, they had evidence that this information was used. Another case in Malaysia was Swenson's Hair Care Center, Sdn Bhd, versus Irene Chin Zi Ling. In this case, the ex-staff left the company. She was a center manager of the PJ branch of the plaintiff's beauty center. She left the company, joined another beauty center, and started contacting the previous customers of her previous employment, asking them to discontinue the treatment with the previous place and to start a new treatment with her current employment. A new beauty place which is called Marique Wellness. So the defendant, as expected, took an injunction suit against her to stop her from contacting any of the customers that the plaintiff had. Here, it's similar to the Smith case. It was in favor of Swenson's. Again, similar to the Smith case, because they have evidence. What happened here was the PJ branch manager there was a witness who actually, one of the customers was sitting at the lobby, and she was a witness in the case, and she saw the PJ branch manager take the loyalty cards, the treatment cards, and photocopy them and put them back. So, and there was no reason to do any photocopying at all. So in this case, that witness submitted that evidence in court, and that was a clear breach of confidential information. Customer list and details are clearly confidential in the case, and it was expressly mentioned in the clause. So they also had a term in the employment contract. And then the number 2 is plaintiff's customer's name, list, and details could not become part of the defendant's own skill, knowledge, and business experience, as the defendant had submitted that there was evidence to show that they had taken the information. So the defendant claimed that her livelihood will be affected if the injunction is granted wasn't accepted by court. Now you can see that the main thing is treating the information as a trade secret, and then with that evidence that you've treated it as trade secret, if there is misuse, that can be prevented, that can be used in court to prevent any further misuse. So now once confidential information has leaked, there's no way you can take it back. The competitor can't be asked to not use the information because it's not a contract between the competitor and the plaintiff. It's a contract between the plaintiff and the ex-employee. So with information, confidential information, it's very risky when it's actually leaked out. And that's risky for many reasons. You get diminished customer confidence, you have loss of revenue, and so on. So here, the 3 things that I would like you to go back with when you're looking at implementing bring your own devices is really the data in your company. How are you treating it? First of all, how are you treating it now before you even have a formal BYOD policy? And then how do you treat it when you have a BYOD policy, which makes it a lot easier for information to be leaked out. Even now, it's easy for it to be leaked out. I'm sure you think about that, or you probably already have strategies in place to prevent it. We have USB drives that can take a lot of information, package your whole company, customer database, and pass it on to a competitor or for an ex-employee to go out and start their own company based on the customer information. I hope I'm not giving ideas here, but you have tons of ways to actually take information out. Emails, for instance. We had a situation once before where we had a colleague of mine who asked for office email to be auto-forwarded to a Gmail account so that they can check the emails from home. And our IT, we engage our IT personnel on a regular basis, and our IT personnel warned us about the danger in that. If you have information being auto-forwarded to Gmail, number 1, they can attach as many documents. If you don't have a limit in your office email account, they can attach as many documents, transfer it to your Gmail. And are you logging their Gmail usage? No, you don't have their password. You're not logging what information that's being transferred. You can log what information is being transferred out, but once you discover it, sometimes it's too late. So if you're transferring it to the Gmail account, you can't actually do anything to prevent it. So that's when we actually put a policy in about, no, you can't use web-based email, you can't do auto-forward to web-based emails. So you're looking at your current systems. There's lots of ways to take information out. You have to cover that hole, find a way to cover that hole to prevent any misuse. And then we bring your own devices. In fact, bring your own devices, I guess Wendy and Eugene can come by. It might even be a better way of controlling it because of softwares that are in place. So here are the 3 things. Identify your trade secret confidential information. Prepare the appropriate clauses in relevant agreements. Review your agreements to make sure it's there. Implement and monitor strict policies on the usage of the information. With that, I would like to end, embrace, bring your own device, and manage the risks in there. Thank you.
No questions. All right, everything must have been very clear. Thank you very much, Ms. Geeta. Please remain on the stage, right, we have some token of appreciation. I'd like to call Mr. SK to represent T-Circle. And we've got something, especially for our Ms. Geeta Kandiah. Thank you very much for being here. Thank you very much once again.